Hi, this is Justin Paperny, and I'm pleased to welcome my colleague and friend, David Rosenfield. David was a U.S. attorney for more than 12 years. He's been a white-collar defense attorney with Herrick Feinstein for more than 12 years. And there's so much that we can cover today with respect to how a white-collar defense attorney can help you, but we're going to focus on proffers. And I wanted to do this video in part because I received a call from a defendant who had a proffer session, and he said, Justin, I've been watching your videos. I wasn't prepared for the proffer. It went horribly. The U.S. attorney thought I was sort of some smug, arrogant guy. That wasn't me. I just didn't know what to expect. So I immediately got on the phone with David, and I wanted to get his advice. Quick disclosure, it's impossible to cover everything in a 10 or 12-minute video on a proffer. We could write a book about it. Okay, so for those of you that want more information, I'm going to put up David's phone number, a link to his bio, his email. You can get in touch with him or me. We'll make it happen. So I want to do an overview of a proffer today by starting off by saying, David, welcome. And what is a proffer agreement for a white-collar defendant who's potentially in an investigation?
Well, what a proffer agreement is, it's an agreement between a client, a potential defendant, and the government, whereby the client agrees to meet with and speak to prosecutors about facts that are relevant to an investigation and that client's potential participation in criminal activity. There is almost always a written proffer agreement that's signed by both the government, by the client, and by the client's attorney. But the proffer session itself it's essentially an interview.
And the interview is it going to take place before someone might plead guilty, earlier in the investigation? When is an ideal time potentially for a proffer? Walk us through that timeline as it could exist.
The best time is early in the investigation. Let's say the government comes and visits you, the FBI agents visit you, and they want to talk to you about your involvement in a case, and you say, well, I want to cooperate, but I want to talk to my attorney.
Okay.
You need an attorney, and then one of the first things the attorney may do is set up a proffer session after preparing you for that proffer session.
So let's walk through some of the pros and cons of a proffer. Clearly, this gentleman who reached out to me, the con went poorly. They didn't get a real appreciation for either his contrition or remorse, and I'm not sure how openly he worked with him or how well he prepared. So let's go through how a proffer can help you, but further, how it could hurt you, including even leading to new charges, I suppose. So how do you prepare a client for a proffer, and what are some of the pros and cons of that proffer?
All right. Well, first of all, in terms of preparing a client for a proffer, you know ahead of time most of the areas that the government's interested in and that they're going to ask you about. Mm-hmm. So it's incumbent upon the white-collar defense attorney to sit down with the client and go over in great detail what questions are likely to be asked and the answers that are likely to be given. If the client has any relevant documents, the documents need to be reviewed and analyzed. So it's critical that the lawyer prepare the client for the proffer session as much as possible. Now, there's always going to be some questions you're not ready for. And if that happens at the proffer session, you can always step outside the room. And the client can say, I'd like to talk to my attorney, or the attorney can say to the client, let's go outside.
Yep.
But it's really critical to be prepared ahead of time for the proffer.
So let's talk about the importance of honesty. Some of the people that reach out to me, they're a little bit in denial, don't fully recognize their conduct and the severity of the situation. A lot of people can be good salesmen and think we might be able to work our way out of this. We want to go in and say we're sorry, and then hopefully get ourselves out of the situation as best we can. We don't fully understand it. So talk a little bit about how a defendant can demonstrate that remorse or that contrition. I mean, you were a U.S. attorney for a long time. You had a lot of proffer sessions. You might have ended these sessions by thinking, this could be a cooperative witness or maybe not. So talk to us about the contrition and remorse you think it's important to convey.
Well, it's important for the client to let the government know if they've been involved in criminal activity, that they are contrite, they are remorseful, and not come in and be arrogant and basically end up with a bad vibe, if you will, with the prosecutors.
Yep.
Prosecutors don't like arrogant people,
Yep.
whether the defendants or not. So you want to show contrition. You want to show that you recognize how serious the charges are or potential charges are, and that you're remorseful for what you did if you committed a crime. And that goes a long way to developing a good relationship with the prosecutors. And you need that good relationship down the line if you end up pleading guilty and you're going to be sentenced. You're looking for a cooperation agreement, that sort of thing.
So to the cons, as you had mentioned, there can be potentially new charges if you mislead them, if you obstruct. I'd like you to touch on that for a moment. A proffer can be a great opportunity, but could also end disastrously. So there can be new criminal charges if they find that you are misleading or lying to them. Is that correct?
Absolutely true. And the two primary charges that they can bring against you are making false statements to government agents, which is called Section 1001 charge, or obstruction of justice. And those types of allegations or charges are often much easier to prove than the underlying substantive crime. So if you lie to the government going in there and they have solid evidence that you've lied, they won't hesitate to bring either of those charges, a false statement or obstruction of justice charge, against your client. And so you have to be completely truthful with the government in a proffer session, and you don't want to admit things or omit things. So if the government has it partly right and not completely right, or they leave things out, you want to correct them, or you want to let them know the things that they haven't thought about or brought forward, so that you're not accused of omitting any material fact.
Something that's interesting, some of the defendants, when they go in, and we want to be perceived in a positive light, we want to help as much as we can, and there can be a tendency, and when I was interviewing with the SEC, I had to manage being 100% honest, but also not wasting their time. They have a lot of cases. This is taxpayer resources, and sometimes, I remember one time I made a statement, and I said it honestly. I didn't know that it was a great thing to say. They asked me a question. I said something like, I wish I knew the answer to that question because it would probably help me, but the truth is I don't know the answer. And the SEC said, that's the perfect answer. Don't waste our time. If you don't know, don't take us down a road that's going to waste our time. And it's easy, I think, for some defendants to maybe want to do that because maybe it could help them. And I just think it's important to convey that point. As I mentioned, we could talk about proffers for hours and hours. I'd love you to talk a little bit more about some thoughts on proffers, some takeaways or keys for defendants to consider what can be a very normal, a very anxiety-filled process. I mean, anytime you meet with the government, David, it's nerve-wracking, it's scary. And so I'd love some takeaways for some defendants to consider.
Well, there's both some very strong pros and very strong cons to proffer sessions and proffer agreements. The pros are basically that you're starting cooperation. And if you come in early, you're cooperating early, and that goes a long way in terms of what the end result's going to be. You'll get a better deal, a better sentence if you come in, you cooperate early, and you're fully truthful, and you lead them to other evidence. So that's basically the pros. The cons are, if you lie to the government during a proffer session, like we said, you're going to be charged with other crimes that are easier to prove. Also, if you submit to a proffer session and then things don't work out and you go to trial, the government, while they can't use direct statements that you made in their case in chief, whatever you say or your attorney says that contradicts what you said in the proffer statement can be used against you. There have been cases where a defense lawyer has gotten up in an opening statement and said, my client's innocent of the charges. Well, guess what? At the proffer session, the client had admitted that he was guilty. That opens the door to the prosecutors to bring in that evidence. So, for example, when a defendant is bringing in a character witness who says, I know how honest the person is and so on, the government could cross them by saying, did you know in his proffer session with us, he admitted guilt to these crimes? So there's some real downside to a proffer session in the sense of it almost forecloses a defendant's ability to defend himself at trial.
Yeah, that was really well said. And let me close with something you touched on. A defendant a few months ago said, "Hey, can a proffer minimize my prison term?" And it kind of can, because if you get in there early enough and you're honest and you're cooperative and show that contrition and remorse and you're credible and your help leads to other indictments perhaps, then down the road that can impact you at sentencing based on how well you were prepared for and how well your proffer went. So it certainly can impact the end game. And I know many of you watch these videos to get to serve the shortest sentence possible in the most favorable institution. And a proffer, going in prepared for a proffer can help. So let me close with how I opened. It would be impossible in this video to cover everything that can come up in a proffer. I encourage you, if you have questions, to reach out to David. Even if it's not New York or New Jersey, I'm thankful that David has helped me find terrific lawyers across the country for clients and defendants that reach out to me. I think it's been Chicago and Detroit and other areas where David's been able to leverage off his referral network. So if you're not in New York or New Jersey, reach out to David. He'll give you some advice. Identify exactly what you might need and put you in touch with someone who's capable, fair, and who has your best interest at heart. So David, phenomenal. Thank you. I look forward to doing it again. I appreciate you sharing your expertise.
Thanks, Justin. I appreciate it.
You're welcome.